Under the California state law, if a victim of domestic violence is called into court, the court can, in fact, mandate that the victim testify against the batterer. And what is rather interesting, odd, and rather sad is that if she ends up not testifying against the batterer, she literally will be held in contempt. But what is also available to the court is the fact that the court will put her in jail if she does not, in fact, testify. And I have to tell you, as someone who has worked on some of these cases, domestic violence is not an easy situation. It really tears a family apart. It tears the couple apart, and it tears children apart. And for us to somehow say that it is okay for us to further split that family by putting mom in jail so that the kids end up in foster care is just absolutely wrong. And then on top of that, how many times have we said to women, report the situation, and the authorities will protect you. The authorities will take care of you. Well, on the one hand, you take the batterer and put that individual in jail. But then when you go to court, the same individuals, the authorities who said, trust us, believe in us, we will take care of you, we are now telling you that if you don't somehow do what we tell you to do, we're going to put you in jail. Isn't that, in an odd way, the same thing that the batterer says to the wife? That if you don't listen to me, then I'm going to go and beat you up. I'm going to throw you around. I'm going to slap you around until you do what I want you to do. And that is the mixed message. This is what we are contributing to those women who are in that unfortunate and a terrible situation of being battered, being beaten. And so what this bill will do is to provide the same kind of protection that we provide to sexual assault cases. In sexual assault cases in the state of California, you cannot compel the victim to testify with that threat of going to jail. And so this simply provides that additional protection. Urge an aye vote.
Question to the author, Mr. President.
Senator Yee.
Senator Yee, I want to begin by just commending you for taking this measure up. The issue of incarceration, I think you've spoken to very ably, very persuasively. The question I have is whether or not counseling is still precluded, mandatory counseling is still precluded as a consequence for contempt in this case, and where you stand on that issue at this time.
At this time, it is still mandatory. Counseling is still not part of this particular bill. We are interested in working with the opposition to try and address that particular issue when it gets over to the east side, if and when it does, in fact, get over to the other house.
Alquist.
I appreciate what Senator Yee is trying to accomplish. I do feel, though, that counseling should be a part of this, and should the bill come back with a counseling component in it, I would be happy to vote for it at that point in time.
Senator Kuehl.
Thank you, Mr. President. I don't know, maybe a lot of other people worked in domestic violence shelters for 15 years before they ran for office on this floor, but I did. And I frankly, of course, whatever Senator Yee does to convince people that, he's being reasonable about the bill and he'll make some changes is fine. It's his bill. But I have to say it is amazing to me to think that a woman who fears for her life and the lives of her children should be counseled so that she can see the error of her ways and come to testify against the person who's threatened to kill her or kidnap her children. This is not about a mental aberration on her part. This is about an appropriate response to a threat. She makes the decision that she cannot testify. We have a number of cases, especially perhaps where a victim is dead, where we ask the police to present evidence and to collect the evidence, and the district attorney to prosecute on the evidence, or the city attorney. These are the same kind of cases. This is what we do in many of the jurisdictions now. But to say that a victim is somehow at fault and should, of course, should not be incarcerated for contempt, this is real fear. These are real cases of real people's lives who are being seriously threatened with death and injury. I think you really have to think about that. Now, a lot of women will say, okay, I'll go to counseling, but, don't ask me to put my children at risk. So I think we have to understand people's real lives here, and a lot of your bills show that you do. This is one of those where you must take into account what the victim's real life is like. I encourage your I vote.
May close.
Mr. President, with the concerns that have been raised by my colleagues, I hear the concern. We will endeavor to try and protect women, and that they are not put through any kinds of consequences whatsoever for not testifying. As you all know, getting a bill through is about finding ways for us to get the votes, preserve the integrity of the bill, and then at the same time hoping it gets signed.
Call the roll, please.
Onnested. Aye. Ackerman. No. Alquist. Ashburn. Aye. Batten. Calderon. Sadil. Aye. Cogdill. No. Corbett. Aye. Correa. Aye. Cox. Aye. Denham. Aye. Ducheney. Dutton. No. Flores. Aye. Harmon. Aye. Hollingsworth. No. Kehoe. Aye. Kuehl. Aye. Lowenthal. Aye. Machado. Aye. Maldonado. Aye. Margette. No. McClintock. Aye. Migden. Aye. Negrete McLeod. Aye. Oropesa. Aye. Padilla. Aye. Parada. Aye. Ridley Thomas. Aye. Romero. Aye. Runner. No. Scott. Aye. Semidian. Steinberg. Aye. Torlakson. Aye. Vincent. Aye. Wiggins. Aye. Weiland. Aye. Yee. Yee. Aye.
Ayes 29, no 6. Measures adopted. File item 34, Senator Padilla.